All right. Good morning, folks. It is January 20th, 9 a.m. And this is the weekly meeting of the Colorado Oil and Gas Conservation Commission. We will start with the roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Bogue. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Great to see everybody. As folks may know, this is our rescheduled hearing. We were due for our normal hearing on Wednesday, January 18th, but state government in Denver shut down as a result of weather. And so we moved our hearing to today. Pleased to see that the agenda items for last Wednesday are all ready for us to hear today. We do not have public comment today. We had 2 public commenters on Wednesday, but they have informed us that they desire to provide their public comment next Wednesday at our normal meeting. So we will take up that public comment then. I would note for the record that we had 2 written public commenters, and I am going to not get the first person's name correctly. Apologize for that. It's Dominica Casalinova, something like that, but we appreciated that written comment. We also had a written comment from Caden Hypo, Hyyypio, and we've all read those comments and appreciate folks taking time out of their day to provide us comment about the work that we're doing here. With that, we will proceed to our agenda. The next agenda item is commissioner comments, and I would look for hands if any commissioner has comments with regard to COGCC and the work we're doing. Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate that. And I just wanted to make known that CPW and COGCC have been working very hard on this year's high priority habitat or HPH map updates. And those are now posted on our website, a preview, so the public can go on there and see those. There's also a stakeholder meeting scheduled for this next Monday to discuss those changes. That meeting will be via Zoom. It'll be at 3 p.m. on Monday. You can also find information on that on the front page of our website under upcoming events. Right next to that, you can see proposed changes to high priority habitat maps, which includes a link where you can go and preview those maps as well. So look forward to talking with anyone who's interested about those high priority habitat maps on Monday. And that's it. Thanks, Mr. Chair.
Great, thanks for the update. Commissioner Cross?
Thank you, Mr. Chair. And Commissioner Ackerman, if I could just ask one question on that. I just want to confirm, will CPW also be at the public hearing or the public meeting on the high priority habitat maps?
Thanks for the clarification, Commissioner Cross. They certainly will be and will be represented there and will be available to answer questions as well.
Thank you.
Did you have anything else, Commissioner Cross?
I'll just say quickly, provide everyone an update. I've continued to do some scoping on the worker certification rulemaking, and I'm hopeful that we can provide some perhaps draft language on that rulemaking soon. And additionally, I just wanted to let everyone know, consistent with House Bill 1348 from last year, staff is working on trying to get the chemical disclosure requirements set up on our website and database. And so that is something that we will be talking with operators about soon as well.
Great, thank you, Commissioner Cross. Any other commissioner comments? All right, seeing none, we now will move to the next agenda item, which is an update on cumulative impact stakeholder process that is being led by Commissioner Ackerman. You are recognized.
Thank you very much, Mr. Chair. Looking forward to chatting about this issue and to updating our stakeholders on this upcoming process. As a reminder, the cumulative impacts issue was discussed during our mission change rulemaking. And while several regulations were implemented during that rulemaking that were intended to reduce and address the cumulative impact of oil and gas development, The commission did commit at that time to take a more focused look at cumulative impacts in general in the future. Remember that in December, we heard a petition on cumulative impacts with regard to air and specifically to ozone precursor emissions. And we at our discussion during that hearing, we committed to conduct a stakeholder outreach process beginning in the first part of this year on the broader issue of cumulative impacts. And so we're pleased today to announce the kickoff of our cumulative impact stakeholder process. Again, want to thank everyone excuse me, who's reached out on this issue. We are excited to move this discussion forward. To nobody's surprise, this is a complex issue, and cumulative impacts mean many different things to many different people. Our goal in this process is to conduct an inclusive process that begins broadly and becomes increasingly focused as we narrow the issues into recommendations that can ultimately be presented to the commission. So in order to do this, we're undertaking a three-phased approach, starting with phase one, which we're calling essentially just scoping. So at the December hearing, the commission stated that we'd like to hear all perspectives and include all points of view in this discussion as we analyze and address it. In order to accomplish that, I'm pleased to announce 4 initial cumulative impacts listening sessions that are intended to be an initial exploration of the cumulative impacts issues. So like this hearing today, these will be virtual meetings. And at these meetings, stakeholders can appear before the commission to raise the issues and points of discussion and topics they believe ought to be looked at within the COGCC cumulative impacts process. Now, some of these issues were certainly raised in the petition and in comments that were responsive to that petition. So we think we know many of the things that are on your minds, but these sessions are intended to ensure all who wish to have a voice are allotted an opportunity to raise any cumulative impacts issue that's important to them. And the issues raised during these meetings will be used to scope our discussion and future phases going forward. So the dates and times of these meetings, incidentally, together with other information that I'll present today, will be available on our website by tomorrow. That will be updated overnight tonight. So the schedule for these meetings, meeting number 1 will be Friday, January 27th from 10 a.m. until noon. Meeting number 2 will be Monday, January 30th from 6 p.m. to 8 p.m. Meeting number 3 will be Friday, February 3rd, 1 p.m. to 3 p.m. And meeting number 4 will be Monday, February 6th, 10 a.m. to noon. On our website, commenters will need to sign up at the links that will be provided in order to secure a time slot to present to the commission at the respective meeting. And I wanted to note also that information from these meetings will be cumulative rather than repetitive. So there will be no need to provide the same information or presentation at multiple meetings. Simply once during one meeting will be enough to implement it insert it into the process. In addition to these meetings, COGCC has created a form that will allow for submission of written comments that are related to this subject. That'll also be found on our website by tomorrow. So please use this form if you prefer to submit written comment. Also, please feel free to use it to submit any information that is supplementary or is reiterating your verbal comments. Also found within the written comment form is an opportunity to volunteer to participate in any future phases of this stakeholder process. So while we don't know at this point exactly what shape that will take, will it be subject focused public meetings or stakeholder panels or subject matter expertise focus groups? We don't know that yet. This form, though, will allow you to volunteer for any such opportunity that may become available during the future phases of this process. So a couple of key points on these scoping comments and issues that will be considered. So those issues that will be considered in this process are issues that are 1, within COGCC's purview and mission, 2, that are consistent with Senate Bill 181, and 3, that are technically feasible to implement. And those criteria are, again, reiterated in the form for written comment. The intent of these meetings is not to debate or discuss or argue for or to refute the merits of any of the issues raised, but simply rather to ensure that there is an avenue to raise and describe those issues that are important to you for inclusion in the discussion, along with any substance around that issue that you'd like to provide. And I also wanted to point out that it's not necessary or productive to organize multiple voices to make the same point in these meetings, or to begin a letter writing campaign to support any particular point or issue. While inevitably some points will be raised by multiple people, all points raised during this process will be analyzed for inclusion into the discussion. Now, I wanted to point out that potential modifications could be made to this scoping process. So for example, if more people sign up to give comment than we have time currently allotted in the meetings that we have scheduled, we'll adjust that. We'll adjust the process until we feel all who wish to participate in raising cumulative impacts, points of discussion have had an opportunity to do so. So once we feel that scoping is complete and we've organized the issues that should be analyzed for inclusion into the discussion, we'll move to phase 2, or what we're calling the technical phase. So COGCC will then digest and organize that information raised during the scoping phase and ensure the issues included in the process meet the intent set forth at scoping. That is, that they are within COGCC's purview and mission, they're consistent with Senate Bill 181, and they're technically feasible and potentially actionable. And then at that point, COGCC will develop further process to engage the stakeholders, staff, agencies, and other resources necessary to work through the technical points of the applicable cumulative impacts issues in order to ultimately focus them into recommendations that meet what I'm calling the 3 goals, that is, that are applicable or within the purview mission and within Senate Bill 181 as boundaries, that are reasonable, that the informed average citizen, that the average informed citizen would find them to be objectively reasonable within the bounds of societal priorities, and that they're feasible. We can actually formulate options to do something about them. So COGCC has not at this stage in the process presupposed what the next phase, the technical phase, will look like as far as stakeholder participation, but intends for the scoping process to help give shape to what the best technical analysis and recommendation approach may be. So we'll have further announcements on the structure of that as it takes shape following the scoping comments. And again, ultimately, the intent of phase 2 is to, in the end, formulate specific consensus recommendations to the commission and to COGCC staff. Once those recommendations are made, that will lead us into phase 3, or the implementation phase. I think it's important to point out that there are certainly a number of implementation vehicles that may be appropriate as the commission considers the recommendations that will be produced by the process. It's inappropriate this time to say what those exactly will be, as we don't yet know. They certainly could or may not include recommendations on rulemaking, COGCC policies, administrative procedures, forms, agency agreements, and other approaches. And at this point, we don't know what that outcome will be. And that will take shape once again as the recommendations come forth from the technical phase. Want to reemphasize that the resultant actions are intentionally not predetermined at this time, but rather the intent of this phase is to explore the most appropriate pathways for recommended actions. And the specifics of the implementation phase will largely be determined by the commission as it sets forth its path forward for addressing any recommendations that emerge to them from phase 2. So in a nutshell, that's the process that we're looking at. We're looking forward to the scoping process coming up in coming weeks. I want to recognize, and no news to anyone, this is a big issue. It's one of the larger issues in scope that we've dealt with as an agency in recent history. So it's a bit messy. It looks a little bit different from some of our previous regimented, focused processes, and that's intentional. We've not defined it from beginning to end at this point, as we expect the process to be an adaptive partnership and adaptive discussion with stakeholders along the way. It will likely be lengthy. The issues that are raised will be complex. They're far-reaching. They involve multiple stakeholders and subject matter experts. And so we will need time to digest and discuss and reach out to stakeholders and to appropriate agencies and other entities that are appropriate in the process. So again, the general framework intentionally is working broadly from identified concepts that stakeholders will bring up, intended then to work together with those stakeholders and any applicable subject matter experts to formulate recommendations that are applicable, reasonable, and feasible to implement, and ultimately lead us forward in addressing further. Again, I pointed out that many cumulative impacts issues have been interspersed throughout our previous actions, but in addressing further cumulative impacts. And hey, we've dealt with big issues before, both us and you. And I'm confident we can do so on this issue as we continually strive to improve our state's management of natural resources and our way of life. So please take a look at our website beginning tomorrow. Find a time that works for you to give comment. please provide written feedback and express your interest in further participation on the issue. And to the stakeholders that are listening, we genuinely look forward to your comments, both oral and written. We very much look forward to this dialogue with you. And we look forward to discussing and developing your scoping comments further as we address this complex subject. Please feel free to reach out to me if you have any questions about the process itself. And to the commissioners, I would just say buckle up for a process that I would expect to be very robust, very thoughtful, and deep. I know certainly that you all are interested in hearing from stakeholders, and I am too. And with that, Mr. Chair, we'll look forward to seeing everyone at the first meeting on January 27th. And I would, at this point, open it up to you, Mr. Chair, or any commissioners that might have comments or clarifying statements.
Thank you, Commissioner Ackerman. Very well done, very thoughtful. Appreciate the work that's gone into coming up with a protocol that can work for our stakeholders on this important issue. I just, as a point of information, I plan on listening into the stakeholder meetings, and I assume that's okay. And we would just notice the fact that the commissioners would be listening in. I do not plan on participating, but just to sort of, gather information as you go along. So we might have Mimi, note that on our calendars that commissioners would have the opportunity to listen in. I don't know that it's mandatory, but I think we're all interested in the topic and appreciate your leadership. Is that fair? Were you anticipating that we might listen in?
Yes, thank you, Mr. Chair. My understanding is that all the commissioners are interested in listening in, and Ms. Larson and I are working together to make sure that proper notice is put forth, since we'll be on the same virtual meeting.
Awesome. Okay, great. Any other questions for Commissioner Ackerman? Commissioner McGowan?
Thank you, Mr. Chair. Thank you, Commissioner Ackerman. I know this is a big lift. I'm just wondering if we're going to post on the website kind of these ground rules that you have set and the kind of the philosophy that you're coming from, so that folks who aren't on the line with us right now kind of have an idea of what we're looking for during these comment sessions.
Yes, thanks, Commissioner McGowan. They are in the written comment form, but to your point, not necessarily have we set them forth on the cumulative impacts page, but I can work with Ms. Castle, and we can talk about helping keep the public informed in that way. So I appreciate the suggestion. I will talk with her.
Anything else, commissioners? Okay, seeing nothing further, I think that we will continue on our agenda. Next on the agenda, we have a consent agenda with 11 hearing officer recommendations and 1 recommended order. Do we have any questions or comments or concerns on consent agenda? Seeing none, do we have a motion to approve consent agenda?
So moved.
Second. Motion from Commissioner Cross, second from Commissioner Messner to approve consent agenda. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. All right. Next up, we have docket 2207-00182. This is a matter in which petitioner Kathleen Kemper's motion to remove petition for review hearing to the commission. This involves Cub Creek Energy. I would, why don't we elevate Attorney Foote to the panel? Ms. Larson, do we have Attorney Foote with us?
We're bringing him in right now.
Great. And the next matter involving KPK, let's get ready to elevate Mr. Jacobs and Ms. Stafford after we're done with this matter. You're muted, Mr. Foote.
I'm here, Mr. Chair. Thank you.
Okay, great. Mr. Foote, I've looked at the motion and I can give you kind of my initial, I mean, if you want to take a couple of minutes to sort of argue the motion, have at it. I have some thoughts and ideas, but I don't want to prejudge it. So do you want to give us a summary of your client's position? And then I've got Mr. Kirschner. I don't know if we need to hear from him or not, but go ahead, Mr. Foote. We'll give you a couple of minutes to argue the merits of your motion.
Yes, I'm happy to, Mr. Chair. I don't think I'll take too much time because I don't really want to repeat what's in the motion that you've reviewed. But, in summary, what's the violations here were severely impactful noise violations on Ms. Kemper. And the motion, and Ms. Kemper believed that the commission should hear that and the commission should speak about that. And particularly what kind of penalty that should draw, how severely it should be taken. And there's really no precedent, Mr. Chair and Commissioners, about this particular issue. Staff did cite a noise violation that it says was similar, or a series of noise violations that said was similar from 2015, but that, as you know, was well before the full-time commission, Senate Bill 181, mission change, and the more of a focus on public health, safety, welfare, and the environment. And so we believe this is a matter for the commission. The commission, as you know, is the body that guides the staff, that will tell the staff what is appropriate, particularly in cases of noise violations. And Ms. Kemper believes that the noise violations that occurred in this case are severe. They should be treated as a major violation as opposed to a moderate violation. So because it's an unanswered issue, or is an issue without precedent, particularly after change, and because it's an important issue about public health, safety, welfare, we believe that it should be commission rather than.
Okay.
Chair, am I the only one losing? I'm hearing Mr. Foote come in and out. Am I the only one? Is that my computer or?
No, I think it's all of us. Mr. Foote, testing 1, 2, 3.
I'm still here. I hope it's not my fault. I apologize if it is.
No,
Maybe just close to the mic.
I think we heard the gist of your motion. Mr. Kirschner, did you have anything by way of response?
No, I would simply state that staff takes no position on the motion. We believe that both the hearing officer and the commission are perfectly competent and able to adequately adjudicate the matter within the bounds put on these matters by the commission and by the rules. One thing I would note is that Mr. Foote did engage in a bit of argument there. Staff would obviously disagree with the position that this is unprecedented, both regarding the impact factor and both regarding precedent cases, but I'll leave that for the pleadings and the ultimate hearing, whoever that ends up in front of.
Okay. And so, Mr. Foote, I have a question. So it seems like this, in my mind, could be a bit premature in that we've not received a hearing officer recommendation yet on this matter, and that the sort of the normal scope, and I'm going to ask Ms. Larson to video herself as well to help me with understanding the procedural matters, but my understanding is the normal scope is that we would receive a hearing officer recommendation, and if your client as a party to the matter had concerns about that, you would have 20 days to object, or there's some other procedural term, and then it would come to us, and we would then be able to hear your client's perspective as well as the perspective of the hearing officer recommendation. Ms. Larson, did I butcher that procedural analysis, or was that close to how things normally proceed?
That is correct. So in this matter, if this is heard by the hearing officer and the hearing officer, upon issuance of his order, that order would then be subject to review by the full commission within 20 days.
Okay. And so, Mr. Foote, I'm just trying to get a sense of how that normal process does not avail your client with the procedural rights and remedies that she should be entitled to. We want to hear if there is objection, but this is sort of taking kind of a left-hand turn a little earlier in the case and trying to figure out the rationale behind that.
Yes, thank you, Mr. Chair. So first I'll mention that I think, as you know, the commission has the discretion to remove something like this and just have the commission hear it. That is what happened with the front range nesting bald eagle study case that you heard. But that did not go to a hearing officer initially. It just went straight to the commission, and the commission made a decision on that. So this would be consistent with what happened there about a year ago. In addition, this looks to be a contested matter. I would imagine that whichever party is on the losing end of this is going to an exception, and it will eventually be at the commission. And so really, I think it's more about efficiency and the commission hearing the matter. The commission, of course, could hear the matter the second time around, but in a contested matter, it just seems to make sense for efficiency purposes that the commission hears it initially, just like it did in the front range nesting bald eagle study case.
Okay, well, thank you for the argument. I will return it to commissioners for deliberation at this point. Commissioners, my perspective is, as I have mentioned earlier, I think we should honor the normal process in most instances and allow these sorts of matters to go to hearing officer first. And then if the party objects, or the complaining party does not feel that they've been heard correctly, then they can appeal that via an exception to us, and then we would hear it then. I think that gives the appropriate record to be created to come before us. And I also, and this is with no due respect to Attorney Foote, who does a great job for his clients, but I just don't like the concept of creating some expectation of parties that there's this ability to sort of move beyond our normal process and take things directly to us. I think in exceptional circumstances, we can use our own discretion to take something up and take it away from hearing officer. In this instance, and again, this is with no prejudging, I don't think this meets that exceptional circumstance sort of scenario. And so I, for one, would be moving to deny the relief requested, and then would be happy to take it up if there is an objection or exception filed by Mr. Foote and his client in the normal process or that we have set up. That's one commissioner's thoughts. I'm looking to hear from other commissioners.
Chair Robbins, I think there's, pardon, I apologize for interrupting, but I think there's a bit of a misunderstanding regarding the procedure. The posture of this petition for review at the moment is not exactly within the normal process flow that you would see as far as enforcement hearings. So the rules provide for a specific complainant enforcement process, specifically rules 510G and rule 524. These allow for, if there is a complainant whose complaint basically initiates the enforcement proceedings, once staff and the operator have reached a draft administrative order by consent, that is then provided to the complainant prior to being taken to the hearing officer for that final review. The complainant then has an opportunity to file what's called a petition for review. And that's what's been done in this case. So the posture is that staff and Cub Creek have reached a draft administrative order by consent. That was then provided to the complainant, and the complainant has specifically filed this pleading known as a petition for review. And then proceedings in this matter will continue pursuant to Rule 524G, which does provide specific procedures for a petition for review hearing. Now, it doesn't specify whether that hearing will be in front of the commission or whether that will be in front of the hearing officer. As I stated earlier, staff has no concerns about either of those bodies hearing this matter, but I just wanted to clarify that this is somewhat outside of the normal enforcement procedure.
And Mr. Kirshner, just to clarify, if the hearing officer retains jurisdiction of this matter, upon issuance of his order, that order is then subject to review by the full commission.
Correct.
I guess that's where I was going with it, is that there is an appeal right that we've not gotten to yet that would still exist for the complainant if they're not comfortable with the order of the hearing officer. And so, Mr. Kirshner, you just indicated in the affirmative that's the case. Is that right?
So once the petition for review is heard, and Mr. Foote, obviously, please feel free to jump in. I don't want to take up too much space here. But once the petition for review is heard, the body that hears the petition for review, whether that's the hearing officer or the commission, once they've decided the outcome of the petition for review, that trier of fact may then act on the AOC itself. So they can dispose of the petition for review however they choose. They can grant it, they can deny it, and then in the same proceeding, they can act on the AOC itself, whether that's the hearing officer or whether that's the commission. And presumably, once that action is taken on the AOC, let's say that the AOC is approved by a hearing officer, then that would go to a recommended order, which would proceed in front of the commission in their portfolios as a normal recommended order does.
Okay. I really want this to be easier rather than more verbose. At the end of the day, if we allow this to proceed to hearing officer, you then provide a recommended order. And I'm looking for everyone to help me here, but at that point, if Mr. Foote's client is not happy with that recommended order, they can file an exception, and then they would have their day in court before the full-blown commission. Is that correct?
That
Ms.
is
Larson.
correct. That is correct, Mr. Chair.
Okay, Mr. Foote, would you like to weigh in on any of this?
I agree, Mr. Chair. There is still an exception process that would be available.
Okay. Having clarified that this commissioner's perspective remains the same, we should follow our normal course of order and allow the hearing officer to hear this. And then if Mr. Foote and his client have concerns with that, we would take it up after they filed an exception, and they would have their day in court before us at that point in time. Other commissioners with thoughts about our process and this matter? Commissioner McGowan.
Thank you, Mr. Chair. Sorry, there's just a lot going back and forth here. So I would like to just clarify that I am understanding. There was a violation. The operator and our staff came to an agreement about that violation and a payment. Normally, then that would be it, and it would come to us unless someone else was involved and they disagreed with the agreement that our staff and the operator came to, and that's what's happening here. And what happened is that could go to a hearing officer for further discussion and for the other involved party to say, this is why I disagree with the agreement, or it could come to the commission. Am I on track so far? Okay. I guess my understanding of the violation is a noise violation. And that is I think based on a matrix that the staff follows. And the argument is about whether or not this is a moderate, or I can't remember the other category of, sorry.
The question is whether it's a moderate versus a major impact.
Okay, can that be, I'm not trying to predetermine anything, but can that actually be changed through a hearing with the hearing officer? Or is that the only option that our staff has because it's predetermined in the matrix? I'm trying to figure out if we already know what's going to happen when it goes to the hearing officer.
I'm happy to answer if that's okay, Chair.
Go ahead.
Sure. So the hearing officer can follow the normal procedure regarding an AOC. Once they act on the petition for review, let's say, just for argument's sake, that they grant the petition for review, they then have the discretion to send the matter back to staff and the operator for negotiations with their guidance, saying that I've granted the petition for review. I believe that they're correct regarding the impact factor. I'm sending it back to you for negotiations with that in mind. So that is a possibility should they grant the petition for review.
And Commissioner, our perspective is that the hearing officer will find that it was a moderate violation, just as staff is recommending. And because really this issue comes down to more of a policy guidance issue to the staff about how to treat severe noise violations. And as I said, there's no precedent for that. That's something the commission will ultimately have to speak about. So that's one of the reasons why we thought the commission should just hear it.
Thank you. I appreciate everyone's feedback.
Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that, and I appreciate the clarifications on the process. I wanted to certainly, and it likely goes without saying, but I'm going to say it anyway. I wanted to recognize that we can very much appreciate that this complaint is the result of real impacts to real people, and so to the complainant themselves, we do appreciate the concern that this has caused you, and the documents that you've submitted. I just wanted to clarify that I agree with the chair that I think, that's the reason that these processes are set up. That's the reason that we have hearings officers, and that's their job in order to, take all of those things into account. And so I am supportive of the entire process playing out and the hearings officer, completing their job on this before it's taken to the full commission, and support the procedures that are set forth as they're intended to allow for multiple opportunities to potentially remedy along the way.
Mr. Mester?
Thank you, Mr. Chair. Thank you to the parties for sharing their thoughts on this. From my perspective, clearly there is an opportunity for this to come in front of the commission either after the hearing officer process or before the hearing officer process, or without the benefit of the hearing officer process, and hear it directly before the commission. I think in both instances, there's certainly going to be opportunities for arguments to be made and transparency to occur, and deliberations that would occur at the commission level. I do find it compelling that if we do find it inevitably coming to the commission, that it may be more efficient to just hear it before the commission. But having said that, I often appreciate the benefit of the recommended order and the process that has gone through the hearing officer prior to it coming before the commission, as it helps provide additional information and clarity on arguments prior to it coming to the commission. I could go either way on this one, to be honest, but if there is an efficiency to be built in by having it heard before the commission prior to or instead of the hearing officer, then I see some value in that, as inevitably we're going to be hearing these arguments in front of us anyway, it appears, without prejudging anything. But I'm not going to die on my sword on this one. If the rest of the commissioners determine that it wants to go in front of the hearing officer first, then I think that's an appropriate path forward. But if there is efficiencies to be had by just having it directly come to the commission, I'm certainly open to that as well.
Commissioner Cross?
Thank you, Mr. Chair. And I'll just say that sometimes the administrative process can be almost inefficient, but at the same time, an important part of the administrative process is to go through the full administrative process. Having done administrative litigation in the past, even though appeals may occur and everything else, you still have to go through the process, and that's why the process exists. And so just despite the knowledge that sometimes it may be inefficient, I think it is important to build the record for it to go before the hearing officer. We don't know what will happen. We have an understanding of what may happen, but it's still important to follow that administrative process that is set before us. And as Commissioner Ackerman said, we do have hearing officers for this reason, and I think it's important to follow that process. So consistent with what a couple other commissioners have said, I think it is important that we do let it go through the process as described, and it not come immediately before the commission without going before the hearing officer.
Thank you, Commissioner Cross. I think I've now heard from 3 commissioners that would vote to not approve the motion and just let this administratively play out. We can call for the vote now. We can have further deliberation. Does anybody care to make a motion?
I move to deny the motion.
I'll second that motion. We have a motion and a second. Is there further discussion? Commissioner Messner.
Thank you, Mr. Chair. I intend to vote to deny the motion as well, but based on the fact that I do appreciate the arguments that have been brought forward by Mr. Foote in trying to develop efficiencies and having it coming directly up to the commission, but am also compelled by the desire from other commissioners to build a full record on this prior to it potentially coming to the commission as an exception. And so I just wanted to clarify that.
I appreciate that, Commissioner Messner, and I would second that clarification that you made. Commissioner Ackerman.
Yeah, thank you, Mr. Chair. And I also wanted to point out, and I meant to do this in my comment, but we are always looking for ways to improve administrative process. And so, you know, if something comes to light in this process that daylights inefficiencies or repetitive pleadings, certainly we should talk more about that. But in the end, I believe that when we set up our process, we intended to do so with each part of the process having specific purpose. And just wanted to flag that if efficiencies are noticed, let's talk about them.
Yeah, and I think that that flag is to Hearings Manager Larson to sort of take this under advisement and take a look with your enforcement officers and determine if there are methods of expediting matters or otherwise that this unique case is sort of brought to bear. And Mr. Foote, I think we would be happy to see you in the normal course of proceedings, and nothing's been prejudged, and I appreciate the work you've done on behalf of your client. With that, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Very good. We'll let the proceeding continue, and like in all likelihood, we'll be seeing Mr. Foote and his client here in a bit. With that, let's move to the next docket, 2011-00261. This involves KP Kaufman and Company. We would want to elevate Mr. Jacobs and Ms. Stafford. And as we're doing that, I'm going to go get some water. I'll be right back. All right, I have my trusty water. Okay, this matter, it's scheduled for KPK's request at the January 25th, 2003. I would note for the record that at approximately 11:08 on Wednesday.
Mr. Chair, we couldn't actually hear you when you leaned down and read that. And so I think it's probably important that we hear the statement.
Let me move my microphone so that I'm nearer to it. Can you hear me okay now? Okay. This matter is set for KPK's request that the January 25th, 2023 commission hearing be held, be in person. But I would note for the record that we received late Wednesday night a motion from KPK that addressed that issue, and it also addressed a second issue that is a request for a 6-month delay of the hearing on compliance. At this point, what I think we should do is allow KPK a few minutes to address both motions, and then we'll allow staff a few minutes to address in response both motions if staff has a response. And then following sort of a short oral presentation, Commissioner can deliberate on either or both motions. Mr. Jacobs, is that a process acceptable?
Yes, Mr. Chairman, that's fine.
Okay, then the floor is yours.
Thank you, Mr. Chairman. Commissioners, good morning. John Jacobs with Davis Graham for KP Kaufman Company, Inc. With me here, should we need him to participate, is Kevin P. Kaufman, President or Chairman and Chief Executive Officer of KPK. We sought an in-person hearing and made that known to opposing counsel and the hearing officer in early December. We raised it at the December 15th initial pre-hearing conference. We awaited some ruling on that in the CMO. We got the CMO from the hearing officer in early January, and it did not address that. And so we again raised it January 6th, I believe. And then a week later, hearings manager Larson indicated that that request for an in-person hearing had to go to the full commission. The hearing officer could not grant that request. We then prepared a motion, but at the same time, there is a much more substantial request that we believe is appropriate to raise at this time. And that is the fruit of several months of labor in getting organized to market the sale of the Spindle Field assets, 835 or so wells and associated flow lines and tank batteries, to a major operator in the DJ Basin. And so we are also seeking a continuance of the compliance hearing currently scheduled for next Wednesday and Thursday for 6 months to allow us to sell our Spindle Field assets for development by another larger operator to inject CO2 for enhanced oil recovery and for geologic sequestration. We believe that a sale of these unique assets can be consummated in this time period, and that interest among other operators in the basin is high. We've engaged the Petrie Partners investment banking firm, Denver headquartered boutique firm that provides the oil and gas industry with advice and marketing services regarding divestitures like this proposed sale. We have likewise also been actively engaged for several months with the U.S. Department of Energy regarding a pilot project to prove up the viability of such a development of this field. That was aided by Senators Hickenlooper and Barrasso on the Senate Energy Committee. KPK has met with Secretary Granholm, Secretary of Energy, and her staff, and the head of carbon sequestration. They have actually come out and visited the field. We have 68,000 acres with 100% lease ownership by KPK in the Sussex and Shannon formations that are unique in the region in that they can take tens of millions of metric tons of CO2, which would allow us to much more rapidly reduce our carbon footprint and move toward the energy transition that the current federal administration and certainly the current state administration very much seek to make happen. More to the point of this commission's concerns regarding KPK and the compliance hearing, the sale and transfer of operatorship for almost 900 wells and associated flow lines would serve to more quickly and effectively address this commission's concerns regarding KPK's operations than proceeding under the compliance plan agreement for the next 4 years and regularly sort of duking it out with staff in front of this commission about, are we in perfect compliance? Are we in substantial compliance? And the like. Proceeding with the compliance hearing as scheduled unnecessarily risks damaging Colorado's ability to more rapidly utilize this unique Spindle Field resource for CCUS development to meet its climate action goals. And removing KPK from operation of that through such a transaction, we think serves everybody's best interests, this commission's and its concerns, staffs, as well as KPK's and the public's. Additionally, a continuance of this time period would conserve this commission's, staff's, and KPK's resources devoted to hearing. And also we would be subject to the many requirements and obligations under the CPA, which we're continuing to operate under. We just submitted our final flow line integrity management plan days ago and are anxious to get staff approval and to begin to implement that to address any high-risk segments and move forward in that manner with our other many plans and requirements. So for those reasons, we urge this commission to strongly consider a 6-month continuance to, if they should deny that, also consider an in-person hearing. The benefits of an in-person hearing, of course, are to better evaluate the demeanor and veracity of testimony, to be able to confront witnesses with rebuttal testimony more effectively. We're all pretty used to virtual meetings, but given the very consequential nature, high risks of this hearing to the company, we'd much prefer an in-person hearing. And so even if you should deny the motion to continue, which again, we urge you to strongly consider and grant. We would request a continuance until a time when we could hold an in-person hearing. We tried to raise this so that you had plenty of time. The hearing officer had plenty of time 6 or 7 weeks ago. And unfortunately, it's only now being addressed by you.
Thank you, Mr. Jacobs. Ms. Stafford, I would recognize you on the part of staff. Do you have response to either motion?
Thank you, Chair Robbins. For the record, this is Assistant Attorney General Caitlin Stafford on behalf of COGCC staff. I do have a response on behalf of staff here. As I will speak first to the motion for the in-person hearing and then move to the motion for continuance. As KPK acknowledges in its recently filed motion, staff has taken no position on KPK's request to hold the hearing in person. And we have confidence that the commission will fairly and properly evaluate this request. But since I have the opportunity to speak, I would like to make 2 brief points with respect to this first piece. First, this commission has conducted very important business virtually for almost 3 years now. Numerous consequential rulemakings and adjudicatory hearings. At those hearings, the commission has had to evaluate the demeanor and veracity of numerous witnesses and their testimony. It appears this commission has accomplished this successfully and will continue to do so at its upcoming virtual hearings. The motion before you offers no example of how, why, or in what manner cross-examining a witness by video conference differs so significantly from cross-examining a witness in person that the former would somehow constitute a potential due process violation. Second, the commission has broad discretion under the Colorado Administrative Procedures Act on how to conduct its business. I am aware of no explicit limitations on virtual hearings in the APA, nor am I aware of how virtual hearing that comports with due process requirements, that is notice and an opportunity to be heard, would be objectionable under law. I would like to move next to the motion for a continuance, and as KPK stated in the motion, staff does not support this motion for continuance. So before you is KPK's motion to continue the hearing set for January 25th to determine KPK's overall compliance with the CPA. And KPK requests this commission continue the hearing set for next Wednesday for at least 6 months so that it can, quote, sell its Spindlefield assets for development by another larger operator to inject CO2 for enhanced oil recovery and geologic sequestration. KPK states this plan constitutes several months of labor, yet filed its motion to continue within a week of this scheduled hearing. But KPK's proffered justifications to continue the hearing have little to do with the subject matter of the actual proceeding before us, which is whether KPK has complied with the compliance plan agreement by achieving closure of its legacy remediation projects and returning to compliance with COGCC rules. Now, there are several factors here that support staff's conclusion that a continuance is not warranted. First, a continuance does little, if anything, to solve the current and ongoing environmental harm imposed by KPK's continued oil and gas operations, and specifically the numerous KPK spills and remediation projects subject to the CPA. In fact, a continuance is likely to exacerbate such harm. By statute, the commission must regulate the development and production of oil and gas in a manner that protects public health, safety, welfare, including the protection of environment and wildlife resources. Now, in exercising the authority granted by statute, the commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and shall protect against adverse environmental impacts. As staff has continually presented to this commission through the enforcement hearings, quarterly update presentations, during the June 2022 compliance hearing, KPK is making little progress in addressing its multitude of impactful remediation projects subject to the compliance plan agreement. Since June, and as we will likely discuss at the upcoming hearing, KPK has closed only one more remediation project on attachment A, bringing their total to 3 out of 58 remediation projects. Staff has also shown during this time that the CPA has excuse me, staff has also shown during this time that the CPA has been in effect, that KPK has by all accounts failed to implement its spill release reporting and training plan and comprehensive waste management plan at numerous spill projects post-dating the CPA. With this continuance, KPK effectively asks staff and this commission to press pause on accountability and to allow KPK to continue on with the CPA when it has already been determined that they have not complied. With so many aging remedial excavations subject to the CPA that remain open and hazardous, combined with KPK's ongoing spill and waste management issues, such a course is in no way protective of public health, safety, welfare, the environment, and wildlife resources. Second, it remains unclear how proceeding with an enforcement matter here will harm the prospects of using a geologic structure for storage. This enforcement action has been ongoing for some time now. Staff originally noticed this consolidated docket for hearing almost 2 years ago. The compliance plan agreement, as you all know, was negotiated following the enforcement hearings in fall 2021, where KPK was found liable for 22 separate violations, found to have engaged in a pattern of violations, and assessed a substantial penalty. The CPA represents a portion of the relief ordered by the commission in light of its findings of liability and determination on KPK's inability to pay the total penalty assessed. To date, and as I briefly mentioned before, we have had multiple hearings. We have had 4 hearings, 3 quarterly updates, 1 evidentiary hearing to discuss the compliance plan agreement and hear from the parties on how things are going. The specter of potentially imposing additional available relief, whether that be unsuspension of penalties, revocations of certificate of clearance, or termination of the CPA, has remained all this time. Therefore, KPK's assertion that this upcoming compliance hearing could somehow more heavily risk the rapid utilization of the Spindle Field for carbon capture sequestration projects does not appear to align with the experiences of the past 14 to 16 months. And third, and to wrap up, there are too many uncertainties with respect to this prospective transaction for staff to have confidence that the outcome KPK presents in its motion will actually come to fruition. At the outset, staff acknowledges that should KPK's plan proceed as has been expressed, it could have a positive impact for the commission and the state of Colorado by helping to reduce greenhouse gas emissions. But based on the lack of information provided about the sale, transfer, and future plans for the Spindle Field, much of this seems speculative. There are many outstanding questions that staff has with respect to future utilization of the Spindle Field, regarding potential sale and transfer, who would take over the environmental liabilities associated with the Attachment A projects. More importantly here from staff's perspective is the uncertainty surrounding KPK's potential ongoing operations in the state. Staff is unclear what it means for KPK to sell its Spindle Field and then continue operating in the state, as if you take a look at the motion, KPK asserts that, quote, the sale and transfer of operatorship for KPK's almost 900 wells and associated flow lines and equipment in the Spindle Field is what would be covered under this sale. But COGCC records indicate KPK has just north of 1,200 wells in this state, meaning that even if this transaction occurs, KPK will remain an operator of some 300 wells. So in conclusion, KPK's proffered justification for continuing this hearing has little to do with the subject matter at issue and does not provide certainty to staff that concerns related to public health, safety, welfare, the environment, and wildlife resources will be addressed in the interim, while a potential sale and transfer of the Spindle Field is merely being pursued. Staff does not support KPK's request to continue next Wednesday's hearing, and we ask that you deny KPK's motion. Thank you.
Ms. Stafford. Mr. Jacobs, I'm going to give you a short amount of time for response or rebuttal. I would note that at least this commissioner has the following that I would like you to address. One, how does a continuance ensure environmental protection for the remaining spills that are ongoing? And two, how does proceeding under the CPA harm the prospects of the sale of the Spindle Field? And three, if you could provide some additional information about the certainty of said sale. Is there a contract in place, or where's your client at? Those are the three things that are of interest to me, at least, in response or rebuttal. And I know generally judges just sort of like let you just spout off in response or rebuttal what you want to hear, but I thought I might go ahead and just daylight some of the things that I thought were important.
Thank you, Mr. Chairman. I appreciate the opportunity to respond. Regarding risks to the environment and harm to the utility to utilize, or the ability to utilize, this important and unique geologic resource for carbon capture and utilization, the staff has urged the commission to consider very substantial penalties and other severe sanctions. Now, you have not prejudged the hearing next week. We believe we can demonstrate substantial compliance. Staff, as you've heard, has previewed their arguments as to why they believe they can show a lack of substantial compliance at the hearing next week. So we don't know, and you don't know, and you won't know until you hear it. But if you were to decide to impose those severe sanctions, the resulting shut-in of operations would immediately require significant maintenance and eventual reclamation obligations, which constitute a much larger problem environmentally and operationally. That could also be avoided by a continuance. Now, to your other, to your other concerns, how does a continuance ensure environmental protection? We've spent over $7 million since the CPA was started. This is undisputed. The dedicated project accounts indicate that. We haven't gotten NFAs, but staff has a lot of discretion with respect to that. We've moved much closer to NFA at a number of sites, as we will demonstrate at hearing if required to do so next week. We have improved our waste management, our spill release response training. Those plans are in place. We dispute vigorously the allegations of staff, and we intend to rebut that. We show excellent operations and management of soil, contaminated soil, where we have BMPs in place. Our fencing is excellent. We're side by side with other operators that sometimes get identified by staff as KPK. We get a notice concerned about those sloppy conditions and point out, no, that's so-and-so's operations next to ours. Look at ours. They're in good shape. The CPA is an unprecedented set of obligations and plans that are now in place and imposed upon KPK. We're moving as quickly as we can under those many obligations, which have lots of hold points, lots of pauses for notice. And so it's a machine that is built for quality, but not for speed, hence the lack of NFAs. And you will hear more about this next week, again, if this motion is denied. Regarding remaining spills, we've responded very well to more recent spills, and we're prepared to show you that as well. And I could summarize information offline to provide you that information in connection with this motion, if that would be helpful. Regarding the certainty of the transaction, these are confidential negotiations. We have non-disclosure agreements in place. We have the preeminent investment banking firm to the oil and gas industry handling mergers, acquisitions, and divestitures for this transaction, and talking with major operators in this basin who are keenly interested in the resource, in the assets. I can't say more publicly. I have Mr. Kaufman here, who, if we went into executive session, could perhaps provide you with more information regarding the state of our efforts. They are serious, ongoing efforts, and they are generating strong interest from very large, responsible operators known to staff, fully bonded under your financial assurance rules. This serves to solve many problems more quickly than we could possibly just plowing ahead and doing battle every 90 or 180 days in front of you under the compliance plan agreement. So it's an opportunity, but it's an opportunity that could be harmed. If you were to decide to take action against KPK and put it out of business or not allow it to sell its production, now we have orphaned wells. This asset immediately is impaired. You immediately have an environmental problem. These all can be cured with a simple 6 months continuance and continued adherence to the CPA, oversight and scrutiny by staff. This is a system that's working, but it can be better and quicker to go through the transaction. Now, lastly, to the 300 wells, these are not the Sussex and Shannon wells, the older 70s and 80s era Amoco vertical wells. These are Codell Niobrara hydraulically fractured wells. There's a couple hundred north and east of the Spindle Field. And then there's 100 wells or so up in North Park in the McCallum Field near Walden. And those are very different. The issues there are clear. The 200 Codell Niobrara wells, they're much newer. There have been no significant problems associated with them. The vast majority of concerns about spills and remediations are associated with the Sussex and Shannon wells in the Spindle Field that we're intending to sell if we could just be allowed the 6 months to negotiate a deal to get that done. We think that would be better for everyone. I hope I've answered your points, Mr. Chairman.
Thank you very much. Commissioners, at this point, we've heard oral argument on the two motions. I would suggest we consider going into executive session to receive legal advice on the two motions at this point. Does any commissioner agree with that as being a potential appropriate next step? And AAG report, see that you're available. Is that something that is available to us at this point?
Yes, certainly, Chair. The commission can go into executive session to receive legal advice on the pending motions.
Second.
Commissioner Cross?
I'd move to executive session.
Sorry, Mr. Chair, Commissioner Cross, I just briefly need to comply with open meetings law by reading my executive session script.
Go ahead, Commissioner AAG Davenport.
Thank you. Commission, pursuant to open meetings law, the commission is entitled to go into executive session at this regular meeting to receive legal advice regarding KPK's pending motions to continue and motions for an in-person hearing. That is pursuant to Colorado Revised Statute section 24.6.402.3A2. This executive session was not noted on the agenda. That's okay. It doesn't have to be. It's come up in the course of this hearing, but it is in regard to a matter that was noticed on the agenda. Mr. Chair, now we can encourage or entertain a motion to go into executive session.
So moved.
Second.
We have a motion from Commissioner Cross and a second from Commissioner Messner to go into executive session for the reasons as articulated by AAG Davenport. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? All right, we will now go into executive session. The way this happens is we will leave this meeting and we will go into a separate noted Zoom meeting that would just contain commissioners and AAG Davenport. And then we will return to this meeting when we're done. I don't think this is going to be tremendously long, maybe 15, 30 minutes, but we would encourage counsel of record to remain in this meeting. You can unvideo yourself and just monitor it. And when we're back, we'll be back. Thank you. Commissioners, let's take a 10-minute break before we initially go into that executive session. So let's plan on being in executive session at 10:25. Okay, 1, 2, 3, 4. Waiting on Commissioner Ackerman. There he is.
I forgot to visualize.
No problem. Okay, we are back in our business agenda Zoom meeting. Would call upon AAG Davenport for next steps in terms of leaving executive session.
Thank you, Mr. Chair. We're returning from executive session. During executive session, the commissioner received legal advice on KPK's pending motions to continue and motions for an in-person hearing. No decisions were made and no votes were taken in that executive session. And now, Mr. Chair, we need a motion to exit the executive session.
So moved.
Second.
Motion and a second to exit executive session. All those in favor signify by saying aye. Aye. Any opposed? All right, we're out of executive session and we're back in our normal meeting. Did you have anything else further at this point, AG Davenport?
I do not.
Okay. All right, commissioners, pending before us are two motions. I'd like to take them in order. First is the motion for I want to take the motion for continuance first, because that then would either negate or moot out the motion for in-person hearing. But I have some thoughts about both. With regard to the motion for continuance, the standard is there good cause for a continuance? And my answer to that question is, I don't know. I believe that in order for us to be versed on whether we ought to allow for basically a stay of this proceeding for 6 months, I want to hear from the parties as to what the current status is. And so I would like to hold the hearing next week. And at the conclusion of that hearing, I at least would be, okay to discuss what the current status is and what the commission desires is the appropriate next step for this company and for the commission and for the state of Colorado. So those are sort of my thoughts. I'm not ready to grant just a generic stay right now. I believe that we've had this teed up for 6 months to get to a compliance hearing and whether there's substantial compliance. I think that issue still needs to be brought to us. And for those reasons, I would not be willing to grant a continuance at this point in time. I'm not of the opinion that I wouldn't necessarily consider it after we've had a chance to hear from the parties about substantial compliance, but I think we ought to have the hearing next week. Others with thoughts about the continuance request? Commissioner Cross?
Thank you, Mr. Chair. I'll just start off saying I'm opposed to a continuance. I think the presentation this morning provided by Mr. Jagus, a couple things stuck out to me. First of all, he indicated that he believes that KPK is in substantial compliance. And frankly, I think that kind of the argument of, potential sanctions or potential repercussions that may come out during next week's hearing could have adverse impacts. And if he truly believes they're in substantial compliance, then I don't really see any harm in continuing and having this hearing move forward as scheduled next week. So that I think is the main thing. And obviously I have some concerns with the motion overall. I think there was several points in time during which some, we'll call them aggressive arguments were made during the motion that I don't think have any true factual or legal basis to them. That includes that, having significant sanctions next week, if imposed, would likely prevent the more rapid development of this resource for enhanced oil recovery or CCUS. And I don't think that any kind of explanation was given as to why that would likely prevent a rapid development of this. Again, I think that if KPK is in substantial compliance, that would have no hindrance on any kind of sale and it could move forward at the same pace. I think that even if there were any kind of sanctions done, there's no ability to continue to have a sale. And I think kind of the idea that any sale would prevent any kind of sale of assets has not been shown at this point in time. Frankly, the only impact I could see sanctions having on any kind of sale would be the sale price. And to me, that is the biggest concern with what I saw. And it sounds to me as though this is kind of a roundabout way of saying, we don't want to have the hearing next week because if we were to have any kind of sanctions levied against us, we would potentially have a sale price that would be lower than it would be if it was continued. And that is not our job here, to protect the sale price of any kind of assets. We're here to make sure that the CPA is being complied with, that environmental impacts are being handled, and that continued oil and gas production is handled in a safe and responsible manner in the state of Colorado. And I don't see any reason why next week's hearing should be continued with that as our underlying obligation as a commission here. If really the only issue is potential sale, the sale can happen one way or another, regardless of any outcome that may happen next week. And so ultimately, that's my biggest concern with this. And frankly, the idea that, you know, this could impact a potential sale was a little frustrating to me, because really the only potential impact I see on a sale is just the price.
Thank you, Commissioner Cross. Others with deliberative thoughts, Commissioner Messner.
Thank you, Mr. Chair. I agree, generally speaking, with Commissioner Cross's analysis of this. I don't think at this time there's been good cause shown as to why this motion would need to be granted at this time. I appreciate, Mr. Chair, your desire to not make a decision on it today, but from this commissioner's standpoint, it seems more appropriate to deny this motion today. And certainly the party has the ability to re-raise the motion at the conclusion of the previously scheduled hearing, should they choose to.
Thank you, Mr. Chair. I appreciate it. Appreciate the opportunity to discuss this here today. I think where I'm coming from largely on this issue is that these are substantial violations that's been acknowledged by all parties. The company is working towards compliance. This is a compliance plan. The intent of these hearings is to ensure consistency and continued effort on that compliance plan. And that's how I view this hearing. I think not only should it not be continued, I think regular check-ins and regular hearings on the compliance so that we can determine on an ongoing basis if KPK is in substantial compliance are imperative to the integrity of the compliance process. So I also am in favor of holding the hearing.
Does anyone care to make a motion?
I move to deny the motion.
I'll second.
Motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay, the motion for a continuance is denied. We will hold the hearing next week. The next matter is whether to hold the hearing in person or not. I'm going to lead again just because I've been thinking about these things. So guys, you know, in my opinion, we have successfully been holding virtual hearings for close to 3 years. I believe we have absolutely afforded our stakeholders and the parties before us due process, and in some instances, more due process than is required by Colorado statute, Colorado rules of procedure, etc. I believe that my ability to listen in and judge the character and the quality of the witnesses and the character of the witnesses is not impinged in the least by a virtual hearing. As a former practicing lawyer for 20 some odd years, I tell you that I think in person is, if we were to pivot to in person for this hearing, we've got more of a sense of due process problems because we're not used to doing in-person hearings, and we're doing a very good job of doing virtual hearings. So it's my preference that we continue as we have been doing. That is to hold the hearing virtually at this point. Again, I do not believe that an in-person hearing is necessary under any process considerations. You know, if there is a super majority that wants to have an in-person meeting, I'm going to be in Denver, and I can certainly be there in person, but I believe that we're better served to continue how we've been doing our meetings And I also am a little concerned about creating a precedent that somehow or another we have to have in-person meetings in order to afford a party's due process. So those are my thoughts on this motion. Others with deliberative thoughts. Commissioner McGowan?
Thank you, Mr. Chair. And I don't necessarily disagree with anything that you've said, other than I guess I'm going to add, I think that online has actually provided an expanded opportunity for folks to participate who weren't able to participate when we used to be just in person, and the requirement was for everyone to be in Denver. So I actually think that our ability to allow participation and folks to see what's happening and participate in what's happening has increased rather than decreased via Zoom. I guess my second concern would be, folks are used to watching us individually and to be able to talk and deliberate. If we're all sitting in, we've had a couple of Zoom meetings for trainings when we're in that room, and you don't really get to see individual commissioners. You can see us at the table, cannot see us individually, and maybe everyone's okay with that. I don't have an issue if we're meeting in person. I guess my thought would be, I don't think that this is a due process issue. I think it's this operator has asked for an in-person, and we're going to be deliberating a pretty serious matter about their future. And so I would be okay meeting in person, but I don't feel strongly about it one way or another.
Thank you, Mr. Chair. Appreciate the comments from Commissioner McGowan and yourself. I think the COGCC is a statewide agency. I think that this agency has embraced the virtual procedures over the last 3 years, and I think has implemented them in incredibly successful way. I think it does allow for strong due process. I think it allows for efficiencies. I think it allows for additional transparency. I think it allows for accessibility to our proceedings to folks around the state. From this commissioner's standpoint, I find no impairment in the determining any kind of demeanor of individuals giving testimony, or my ability to ask questions to counsel or witnesses. By all accords, I think it actually creates a cleaner, more efficient, and more transparent process. And we've been doing this process as our standard procedure for a number of years now in a successful manner. So I don't see any need to modify our way of doing things at this point.
Commissioner Ackerman, Commissioner Cross, any deliberative thoughts? Commissioner Ackerman.
I do. Thanks, Mr. Chair. And I would say that I am, with regard to the comments that have been raised with regard to ascertaining the demeanor of witnesses or to being able to question folks, I'm very indifferent as to whether it's in person or whether it's virtual. I think it's one and the same as far as being able to have an effective and efficient proceeding. I do think it's within the purview of the commission to do an in-person or a virtual meeting. And I guess I did have one clarifying question, and this might be to Ms. Larson, that if we did an in-person hearing, I presume that there would be an opportunity for virtual participation, and an in-person meeting would essentially be a hybrid meeting. Would that be a correct statement?
That is correct.
Okay, thank you. One of the, as was pointed out, one of the benefits of having a virtual meeting is broad and wide participation. I do think that, a hybrid meeting would offer broad and wide participation. One of the issues with a hybrid meeting is that then you do have some people in person and some people virtual, and that is a bit of a different playing field, in my opinion. And so I would lean towards maintaining the effective virtual hearings that we're having. But like you, Mr. Chair, if there are folks that feel strongly on the commission about an in-person hearing, I certainly would be willing.
Commissioner Cross.
Thank you, Mr. Chair. I'll start off saying I think I fall in the same boat as Commissioner McGowan. I see no reason to think that in-person hearing compared to a remote hearing would, at least with respect to this commissioner, affect the ability for me to evaluate the veracity of witnesses, the veracity of evidence provided. And as has been said continually, I think that we've done a good job of having remote meetings. That said, I do understand that there are significant stakes at issue here. I will also be in the office next week for them. So if people do want to have it in person, I will be there. But I appreciate the severity of the issue at hand and will likely be, like I said, in the office. And so I'd be fine with it being in person, but I don't see any necessity from a legal basis as to why it would have to be in person.
Thank you, commissioners, for your deliberative thoughts. Having heard from everybody, I would move to deny the motion for an in-person hearing. The basis for that is, as is indicated by all of our commissioners, we have an ability to have due process considerations met. I think every one of us has said that we have an ability to understand the credibility of witnesses and all that. I also would point out that, in my opinion, I've not seen any attorney have an inability to be able to, cross-examine witnesses as to character and all of that via hybrid or via a virtual meeting. I also would have as a basis for my motion that I think pivoting to in-person or pivoting to hybrid, in my opinion, creates more uncertainties with regard to considerations of due process because we haven't been doing it for 3 years. I think we need to, probably create some parameters and some procedures about the in-person nature of a meeting. And so for all those reasons, I would vote that we continue our normal course of conduct and have the meeting virtually.
Second.
Motion and a second. Is there further discussion? Commissioner McGowan?
Thank you, Mr. Chair. I am going to reiterate that I agree with you, Mr. Chair, that we haven't been doing it, so I don't know if it's going to be a better experience or a worse experience if we were to do it. That being said, this was requested by the operator, and so let's see, I will be a no vote on this. I'm not sure how I'm going to be voting. I'm voting to allow the in-person meeting, so I need clarification how I would be voting.
Would be voting no.
Okay.
Further discussion? Since we've got at least one no vote and some yes votes possibly, let's have a roll call.
Commissioner Ackerman,
Yes.
Commissioner Cross,
No.
Commissioner McGowan,
No.
Commissioner Mesner,
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, excuse me, one moment. The motion passed by a vote of 3 yeses to 2 noes.
Okay, thank you very much. With that, I believe we have concluded our business for today. Is there any further business before the commission? Seeing none, looking for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye.
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 All those opposed? Motion carries. We are adjourned. We will see everybody Wednesday for our next hearing. Thank you.
Thank you.